Hello, everyone. We're going to wrap up SFFA v. Harvard. So, right now we're in Justice Sotomayor's dissent. As noted above, this court suggests that the use of race in college admissions is unworkable because respondents' objectives are not sufficiently measurable, focused, concrete, and coherent. How much more precision is required, or how universities are supposed to meet the court's measurability requirement, the court's opinion does not say. That is exactly the point. The court is not interested in crafting a workable framework that promotes racial diversity on college campuses. Instead, it announces a requirement designed to ensure all race conscious plans fail. Any increased level of precision runs the risk of violating the court's admonition that colleges and universities operate their race conscious admissions policies with no specified percentages and no specified numbers firmly in mind. Thus, the majority's holding puts schools in an untenable position. It creates a legal framework where race conscious plans must be measured with precision but also must not be measured with precision. That holding is not meant to infuse clarity into the strict scrutiny framework. It is designed to render strict scrutiny fatal in fact. Indeed, the court gives the game away when it holds that, to the extent respondents are actually measuring their diversity objectives with any level of specificity, for example, with a focus on numbers or specific numerical commitment, their plans are unconstitutional. See Justice Thomas's concurring opinion. I highly doubt any university will be able to show a measurable state interest. The court also holds that Harvard's and UNC's race conscious programs are unconstitutional because they rely on racial categories that are imprecise, opaque, and arbitrary. To start, the racial categories that the court finds troubling resemble those used across the federal government for data collection, compliance reporting, and program administration purposes, including, for example, by the U.S. Census Bureau. Surely, not all federal grant and aid benefits, drafting of legislation, urban and regional planning, business planning, and academic and social studies that flow from census data collection are constitutionally suspect. The majority presumes that it knows better and appoints itself as an expert on data collection methods, calling for a higher level of granularity to fix a supposed problem of over inclusiveness and under inclusiveness. Yet it does not identify a single instance where respondents' methodology has prevented any student from reporting their race with the level of detail they preferred. The record shows that it is up to students to choose whether to identify as one, multiple, or none of these categories. To the extent students need to convey additional information, students can select subcategories or provide more detail in their personal statements or essays. Students often do so. See, for example, here, a student responded discussing her Latina identity on her application, and here, student responded testifying that he wrote about his Vietnamese identity on his application. Notwithstanding this court's confusion about racial self-identification, neither students nor universities are confused. There is no evidence that the racial categories that respondents use are unworkable. Cherry picking language from Grutter, the court also holds that Harvard's and UNC's race conscious programs are unconstitutional because they do not have a specific expiration date. This new durational requirement is also not grounded in law, facts, or common sense. Grutter simply announced a general expectation that the use of racial preferences would no longer be necessary in the future. As even SFFA acknowledges, those remarks were nothing but aspirational statements by the Grutter court. Yet this court suggests that everyone, including the court itself, has been misreading Grutter for 20 years. Grutter, according to the majority, requires that universities identify a specific endpoint for the use of race. Justice Kavanaugh, for his part, suggests that Grutter itself automatically expires in 25 years after either the college class of 2028 or the college class of 2032. A faithful reading of this court's precedents reveals that Grutter held nothing of the sort. True, Grutter referred to 25 years, but that arbitrary number simply reflected the time that had elapsed since the court first approved the use of race in college admissions in Bakke. It is also true that Grutter remarked that race-conscious admissions policies must be limited in time, but it did not do so in a vacuum, as the court suggests. Rather than impose a fixed expiration date, the court tasked universities with the responsibility of periodically assessing whether their race conscious programs are still necessary. Grutter offered as examples sunset provisions, periodic reviews, and experimenting with race neutral alternatives as they develop. That is precisely how this court has previously interpreted Grutter's command. See Fisher 2. It is the university's ongoing obligation to engage in constant deliberation and continued reflection regarding its admissions policies. Grutter's requirement that universities engage so in periodic reviews so the use of race can end as soon as practicable is well grounded in the need to ensure that race is employed no more broadly than the interest demands. That is, it is grounded in strict scrutiny. By contrast, the court's holding is based on the fiction that racial inequality has a predictable cutoff date. Equality is an ongoing project in a society where racial inequality persists. A temporal requirement that rests on the fantasy that racial inequality will end at a predictable hour is illogical and unworkable. There is a sound reason why this court's precedents have never imposed the majority's strict deadline. Institutions cannot predict the future. Speculating about a day when consideration of race will become unnecessary is arbitrary at best and frivolous at worst. There is no constitutional duty to engage in that type of shallow guesswork. Harvard and UNC engage in the ongoing review that the court's precedents demand. They use their data to scrutinize the fairness of their admissions programs, to assess whether changing demographics have undermined the need for a race-conscious policy, and to identify the effects, both positive and negative, of the affirmative action measures they deem necessary. The court holds, however, that respondents' attention to numbers amounts to unconstitutional racial balancing, but some attention to numbers is both necessary and permissible. Universities cannot blindly operate their limited race conscious programs without regard for any quantitative information. Increasing minority enrollment is instrumental to the educational benefits that respondents seek to achieve. And statistics, data, and numbers have some value as a gauge of respondents' ability to enroll students who can offer underrepresented perspectives. By removing universities' ability to assess the success of their programs, the court obstructs these institutions' ability to meet their diversity goals. Justice Thomas, for his part, offers a multitude of arguments for why race-conscious college admissions policies supposedly burden racial minorities. None of them has any merit. He first renews his argument that the use of race in holistic admissions leads to the inevitable underperformance of Black and Latino students at elite universities because they are less academically prepared than the white and Asian students with whom they must compete. Justice Thomas speaks only for himself. The court previously declined to adopt this so-called mismatch hypothesis for good reason. It was debunked long ago. The decades-old studies advanced by the handful of authors upon whom Justice Thomas relies have major methodological flaws, are based on unreliable data, and do not meet the basic tenets of rigorous social science research. By contrast, many social scientists have studied the impact of elite educational institutions on student outcomes, and have found, among other things, that attending a more selective school is associated with higher graduation rates and higher earnings for underrepresented minority students, conclusions directly contrary to mismatch. This extensive body of research is supported by the most obvious data point available to this institution today. The three justices of color on this court graduated from elite universities and law schools with race-conscious admissions programs, and achieved successful legal careers despite having different educational backgrounds than their peers. A discredited hypothesis that the court previously rejected is no reason to overrule precedent. Justice Thomas claims that the weight of this evidence is overcome by a single, more recent article published in 2016. That article, however, explains that studies supporting the mismatch hypothesis yield misleading conclusions, overstate the amount of mismatch, preclude one from drawing any concrete conclusions, and rely on methodologically flawed assumptions that lead to an upwardly biased estimate of mismatch. See affirmative action and the quality fit trade-off. Economists should be very skeptical of the mismatch hypothesis. Notably, this refutation of the mismatch theory was co-authored by one of SFFA's experts, as Justice Thomas seems to recognize. Citing nothing but his own long-held belief, Justice Thomas also equates affirmative action in higher education with segregation, arguing that racial preferences in college admissions stamp Black and Latino students with a badge of inferiority. Here, quoting Adirond, Justice Thomas concurring in part and concurring in judgment. Studies disprove this sentiment, which echoes tropes of stigma that were employed to oppose Reconstruction policies. For example, here, a study of 7 law schools showing that stigma results from racial stereotypes that have attached historically to different groups regardless of affirmative action's existence. Indeed, equating state sponsored segregation with race conscious admissions policies that promote racial integration trivializes the harm of segregation and offends Brown's transformative legacy. School segregation has a detrimental effect on black students by denoting the inferiority of their status in the community and by depriving them of some of the benefits they would receive in a racially integrated school system. In sharp contrast, racial conscious college admissions ensure that higher education is visibly open to inclusive of talented and qualified individuals of every race and ethnicity. These two uses of race are not created equal. They are not equally objectionable. Relatedly, Justice Thomas suggests that race conscious admissions policies harm racial minorities by increasing affinity based activities on college campuses. Not only is there no evidence of causal connection between the use of race in college admissions and the supposed rise of those activities, but Justice Thomas points to no evidence that affinity groups cause any harm. Affinity based activities actually help racial minorities improve their visibility on college campuses and decrease racial stigma and vulnerability to stereotypes caused by conditions of racial isolation and tokenization. See brief of respondents, collecting student testimony demonstrating that affinity groups beget important academic and social benefits for racial minorities. And then Harvard Working Group on Diversity and Inclusion report, noting that concerns that culturally specific spaces or affinity themed housing will isolate student minorities are misguided because those spaces allow students to come together to deal with intellectual, emotional, and social challenges. Citing no evidence, Justice Thomas also suggests that race conscious admissions programs discriminate against Asian American students. It is true that SFFA alleged that Harvard discriminates against Asian American students. Specifically, SFFA argued that Harvard discriminates against Asian American applicants vis-a-vis white applicants through the use of the personal rating, an allegedly highly subjective component of the admissions process that is susceptible to stereotyping and bias. It is also true, however, that there was a lengthy trial to test those allegations, which SFFA lost. Justice Thomas points to no legal or factual error below, precisely because there is none. To begin, this part of SFFA's discrimination claim does not even fall under the strict scrutiny framework in Grutter and its progeny, which concerns the use of racial classifications. The personal rating is a facially race-neutral component of Harvard's admissions policy. Therefore, even assuming for the sake of argument that Harvard engages in racial discrimination through the personal rating, there is no connection between that rating and the remedy that SFFA sought and that the majority grants today, ending the limited use of race in the entire admissions process. In any event, after assessing the credibility of fact witnesses and considering extensive documentary evidence and expert testimony, the courts below found no discrimination against Asian Americans. There is no question that the Asian American community continues to struggle against potent and dehumanizing stereotypes in our society. It is precisely because racial discrimination persists in our society. However, that the use of race in college admissions to achieve racially diverse classes is critical to improving cross-racial understanding and breaking down racial stereotypes. Indeed, the records show that some Asian American applicants are actually advantaged by Harvard's use of race, and eliminating consideration of race would significantly disadvantage at least some Asian American applicants. Race-conscious holistic admissions that contextualize the racial identity of each individual allow Asian American applicants who would be less likely to be admitted without a comprehensive understanding of their background, to explain the value of their unique background, heritage, and perspective. Because the Asian American community is not a monolith, race-conscious holistic admissions allow colleges and universities to consider the vast differences within that community. Harvard's application files show that race-conscious holistic admissions allow Harvard to value the diversity of Asian American applicants' experiences. Moreover, the admissions rates of Asian Americans at institutions with race-conscious admissions policies, including at Harvard, have been steadily increasing for decades. By contrast, Asian American enrollment declined at elite universities that are prohibited by state law from considering race. At bottom, race-conscious admissions benefit all students, including racial minorities. That includes the Asian American community. Finally, Justice Thomas belies reality by suggesting that experts and elites with views similar to those that motivated Dred Scott and Plessy are the ones who support race-conscious admissions. The plethora of young students of color who testified in favor of race consciousness proves otherwise. See infra, discussing numerous amici from many sectors of society supporting respondents' policies. Not a single student, let alone any racial minority, affected by the court's decision testified in favor of SFFA in these cases. In its radical claim to power, the court does not even acknowledge the important reliance interests that this court's precedents have generated. Significant rights and expectations will be affected by today's decision nonetheless. Those interests supply added force in favor of stare decisis. Students of all backgrounds have formed settled expectations that universities with race conscious policies will provide diverse, cross cultural experiences that will better prepare them to excel in our increasingly diverse world. Respondents in other colleges and universities with race conscious admissions programs similarly have concrete reliance interests because they have spent significant resources in an effort to comply with this court's precedents. Universities have designed courses that draw on the benefits of a diverse student body, hired faculty whose research is enriched by the diversity of the student body, and promoted their learning environments to prospective students who have enrolled based on the understanding that they could obtain the benefits of diversity of all kinds. Universities also have expended vast financial and other resources in training thousands of application readers on how to faithfully apply this court's guardrails on the use of race in admissions. Yet today's decision abruptly forces them to fundamentally alter their admissions practices. As to Title VI in particular, colleges and universities have relied on Grutter for decades in accepting federal funds. The court's failure to weigh these reliance interests is a stunning indictment of its decision. The use of race in college admissions has had profound consequences by increasing the enrollment of underrepresented minorities on college campuses. This court presupposes that segregation is a sin of the past and that race conscious college admissions have played no role in the progress society has made. The fact that affirmative action in higher education has worked and is continuing to work is no reason to abandon the practice today. See Shelby County v. Holder, quoting Justice Ginsburg dissenting, "It is like throwing away your umbrella in a rainstorm because you are not getting wet." Experience teaches that the consequences of today's decision will be destructive. The two lengthy trials below simply confirmed what we already knew. Superficial colorblindness in a society that systematically segregates opportunity will cause a sharp decline in the rates at which underrepresented minority students enroll in our nation's colleges and universities, turning the clock back and undoing the slow yet significant progress already achieved. See Shoot with Sotomayor dissenting, collecting statistics from states that have banned the use of race in college admissions. And then also the Amherst brief, noting that eliminating the use of race in college admissions will take black student enrollment at elite universities back to levels this country saw in the early 1960s. After California amended its state constitution to prohibit race-conscious college admissions in 1996, for example, freshman enrollees from underrepresented minority groups dropped precipitously in California public universities. The decline was particularly devastating at California's most selective campuses, where the rates of admission of underrepresented groups dropped by 50% or more. At the University of California, Berkeley, a top public university not just in California but also nationally, the percentage of black students in the freshman class dropped from 6.32% in 1995 to 3.37% in 1998. Latino representation similarly dropped from 15.57% to 7.28% during that period at Berkeley, even though Latinos represented 31% of California public high school graduates. To this day, the student population at California universities still reflects a persistent inability to increase opportunities for all racial groups. For example, as of 2019, the proportion of black freshmen at Berkeley was 2.76%, well below the pre-constitutional amendment level in 1996, which was 6.32%. Latinos composed about 15% of freshman students at Berkeley in 2019, despite making up 52% of all California public high school graduates. See the brief of University of Michigan as amicus, noting similar trends at the University of Michigan from 2006, the last admission cycle before Michigan's ban on race-conscious admissions took effect. Through present. Explaining, and then see here, explaining that the university's experience is largely consistent with other schools that do not consider race as a factor in admissions, including, for example, the University of Oklahoma's most prestigious campus. The costly result of today's decision harms not just respondents and students, but also our institutions and democracy and democratic society more broadly. Dozens of amici from nearly every sector of society agree that the absence of race-conscious college admissions will decrease the pipeline of racially diverse college graduates to crucial professions. Those amici include the United States, which emphasizes the need for diversity in the nation's military, and in the federal workforce more generally. See here, discussing various federal agencies, including the Federal Bureau of Investigation and the Office of the Director of National Intelligence. The United States explains that the nation's military strength and readiness depend on a pipeline of officers who are both highly qualified and racially diverse, and who have been educated in diverse environments that prepare them to lead increasingly diverse forces. That is true not just at the military service academies, but at civilian universities, including Harvard, that host Reserve Officers Training Corps, ROTC, programs and educate students who go on to become officers. Top former military leaders agree. See brief for Charles S. Babbitt, Admiral Charles S. Babbitt, noting that in amici's professional judgment, the status quo, which permits service academies and civilian universities to consider racial diversity as one factor among many in their admissions practices, is essential to the continued vitality of the U.S. military. Indeed, history teaches that racial diversity is a national security imperative. During the Vietnam War, for example, lack of racial diversity threatened the integrity and performance of the nation's military because it fueled perceptions of racial/ethnic minorities, serving as cannon fodder for white military leaders. Based on lessons from decades of battlefield experience, it has been the longstanding military judgment across administrations that racial diversity is essential to achieving a mission-ready military and to ensuring the nation's ability to compete, deter, and win in today's increasingly complex global security environment. The majority recognizes the compelling need for diversity in the military and the national security implications at stake, but it ends race conscious college admissions at civilian universities, implicating those interests anyway. Amici also tell the court that race conscious college admissions are critical for providing equitable and effective public services. State and local governments require public servants educated in diverse environments who can identify, understand, and respond to perspectives in our increasingly diverse communities. Likewise, increasing the number of students from underrepresented backgrounds who join the ranks of medical professionals improve healthcare access and health outcomes in medically underserved communities. See brief of Association of American Medical Colleges as amici, noting that also that all physicians become better practitioners when they learn in a racially diverse environment. So too, greater diversity within the teacher workforce improves student academic achievement in primary public schools. See brief of Massachusetts, and then see the brief for American Federation of Teachers. There are few professions with broader social impact than teaching. A diverse pipeline of college graduates also ensures a diverse legal profession, which demonstrates that the justice system serves the public in a fair and inclusive manner. See the brief of the American Bar Association as amicus, and brief for law firm Anti-Racism Alliance as amicus. More than 300 law firms in all 50 states supporting race-conscious college admissions in light of the influence and power that lawyers wield in the American system of government. Examples of other industries and professions that benefit from race-conscious college admissions abound. American businesses emphasize that a diverse workforce improves business performance, better serves a diverse consumer marketplace, and strengthens the overall American economy. A diverse pipeline of college graduates also improves research by reducing bias and increasing group collaboration. It creates a more equitable and inclusive media industry that communicates diverse viewpoints and perspectives. It also drives innovation in an increasingly global science and technology industry. Today's decision further entrenches racial inequality by making these pipelines to leadership roles less diverse. A college degree, particularly from an elite institution, carries with it the benefit of powerful networks and the opportunity for socioeconomic mobility. Admission to college is therefore often the entry ticket to top jobs in workplaces where important decisions are made. The overwhelming majority of members of Congress have a college degree. So do most business leaders. Indeed, many state and local leaders in North Carolina attended college in the UNC system. More than half of judges on the North Carolina Supreme Court and Court of Appeals graduated from the UNC system, for example, and nearly a third of the governor's cabinet attended UNC. A less diverse pipeline to these top jobs accumulates wealth and power unequally across racial lines, exacerbating racial disparities in a society that already dispenses prestige and privilege based on race. The court ignores the dangerous consequences of an America where its leadership does not reflect the diversity of the people. A system of government that visibly lacks a path to leadership open to every race cannot withstand scrutiny in the eyes of the citizenry. C. Grutter, gross disparity in representation leads the public to wonder whether they can ever belong to our nation's institutions, including this one, and whether those institutions work for them. And then transcript of oral argument. The court is going to hear from 27 advocates in this sitting of the oral argument calendar, and 2 are women, even though women today are 50% or more of law school graduates. And I think it would be reasonable for a woman to look at that and wonder, is that a path that's open to me to be a Supreme Court advocate? Remarks of Solicitor General Elizabeth Prelogger. By ending race-conscious college admissions, this court closes the door of opportunity, and the court's precedents helped open to young. This court closes the door of opportunity that the court's precedents helped open to young students of every race. It creates a leadership pipeline that is less diverse than our increasingly diverse society, reserving positions of influence, affluence, and prestige in America for a predominantly white pool of college graduates. At its core, today's decision exacerbates segregation and diminishes the inclusivity of our nation's institutions in service of superficial neutrality that promotes indifference to inequality and ignores the reality of race. True equality of educational opportunity in racially diverse schools is an essential component of the fabric of our democratic society. It is an interest of the highest order and a foundational requirement for the promotion of equal protection under the law. Brown recognized that passive race neutrality was inadequate to achieve the constitutional guarantee of racial equality in a nation where the effects of segregation persist. In a society where race continues to matter, there is no constitutional requirement that institutions attempting to remedy their legacies of racial exclusion must operate with a blindfold. Today, this court overrules decades of precedent and imposes a superficial rule of race blindness on the nation. The devastating impact of this decision cannot be overstated. The majority's vision of race neutrality will entrench racial segregation in higher education because racial inequality will persist so long as it is ignored. Notwithstanding this court's actions, however, society's progress toward equality cannot be permanently halted. Diversity is now a fundamental American value, housed in our varied and multicultural American community that only continues to grow. The pursuit of racial diversity will go on. Although the court has stripped out almost all uses of race in college admissions, universities can and should continue to use all available tools to meet society's needs for diversity in education. Despite the court's unjustified exercise of power, the opinion today will serve only to highlight the court's own impotence in the face of an America who cries for equality resound. As has been the case before in the history of American democracy, the arc of the moral universe will bend toward racial justice, despite the court's efforts today to impede its progress. Quoting Martin Luther King, Justice Jackson, with whom Justice Sotomayor and Justice Kagan joined dissenting, gulf-sized race-based gaps exist with respect to the health, wealth, and well-being of American citizens. They were created in the distant past, but have indisputably been passed down to the present day through the generations. Every moment these gaps persist is a moment in which this great country falls short of actualizing one of its foundational principles, the self-evident truth that all of us are created equal. Yet today, the court determines that holistic admissions programs like the one that the University of North Carolina, UNC, has operated consistent with Grutter v. Bollinger are a problem with respect to achievement of that aspiration, rather than a viable solution, as has long been evident to historians, sociologists, and policymakers alike. Justice Sotomayor has persuasively established that nothing in the Constitution or Title VI prohibits institutions from taking race into account to ensure the racial diversity of admits in higher education. I join her opinion without qualification. I write separately to expound upon the universal benefits of considering race in this context, in response to a suggestion that has permeated this legal action from the start. Students for Fair Admissions, SFFA, has maintained, both subtly and overtly, that it is unfair for a college's admissions process to consider race as one factor in a holistic review of its applicants. This contention blinks both history and reality in ways too numerous to count. But this response is simple. Our country has never been colorblind. Given the lengthy history of state sponsored race based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well documented intergenerational transmission of equality that still plagues our citizenry. It is that inequality that admissions programs such as UNC's help to address, to the benefit of us all. Because the majority's judgment stunts that progress without any basis in law, history, logic, or justice, I dissent. Imagine two college applicants from North Carolina, John and James. Both trace their family's North Carolina roots to the year of UNC's founding in 1789. Both love their state and want great things for its people. Both want to honor their family's legacy by attending the state's flagship educational institution. John, however, would be the seventh generation to graduate from UNC. He is white. James would be the first. He is black. Does the race of these applicants properly play a role in UNC's holistic merits based admissions process? To answer that question, a page of history is worth a volume of logic. Many chapters in America's history appear necessary given the opinions that my colleagues in the majority have issued in this case. Justice Thurgood Marshall recounted the genesis. 350 years ago, the African American was dragged to this country in chains to be sold into slavery. Uprooted from his homeland and thrust into bondage for forced labor, the slave was deprived of all legal rights. It was unlawful to teach him to read. He could be sold away from his family and friends at the whim of his master, and killing or maiming him was not a crime. The system of slavery brutalized and dehumanized both master and slave. Slavery should have been, and was to many, self-evidently dissonant with our avowed founding principles. When the time came to resolve that dissonance, 11 states chose slavery. With the Union's survival at stake, Frederick Douglass noted, Black Americans in the South were almost the only reliable friends the nation had, and but for their help, the rebels might have succeeded in breaking up the Union. After the war, Senator John Sherman defended the proposed 14th Amendment in a manner that encapsulated our Reconstruction framers' highest sentiments. We are bound by every obligation by Black Americans' service on the battlefield, by their heroes who are buried in our cause, by their patriotism in the hours that tried our country. We are bound to protect them and all their natural rights. To uphold that promise, the framers repudiated this court's holding in Dred Scott v. Sanford by crafting Reconstruction amendments and associated legislation that transformed our Constitution and society. Even after this second founding, when the need to right historical wrongs should have been clear beyond cavil, opponents insisted that vindicating equality in this manner slighted white Americans. So, when the Reconstruction Congress passed a bill to secure all citizens the same civil rights as enjoyed by white citizens, President Andrew Johnson vetoed it because it discriminated in favor of the African American. That attitude and the nation's associated retreat from Reconstruction made prophecy out of Congressman Thaddeus Stevens' fear that those states will all keep up this discrimination and crush to death the hated freedmen. And this court facilitated that retrenchment. Not just in Plessy v. Ferguson, but in almost every instance, the court chose to restrict the scope of the second founding. Thus, 13 years pre-Plessy in the civil rights cases, our predecessors on this court invalidated Congress's attempt to enforce the Reconstruction Amendments via the Civil Rights Act of 1875, lecturing that there must be some stage when Black Americans take the rank of a mere citizen and cease to be the special favorite of the laws. But Justice Harlan knew better. He responded, what the nation, through Congress, has sought to accomplish in reference to black people is what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as freedmen and citizens, nothing more. Justice Harlan dissented alone, and the betrayal that this court enabled had concrete effects. Enslaved black people had built great wealth, but only for enslavers. No surprise then that freedmen leapt at the chance to control their own labor and to build their own financial security. Still, white Southerners often simply refused to sell land to blacks, even when not selling was economically foolish. To bolster private exclusion, states sometimes passed laws forbidding such sales. The inability to build wealth Most Americans of means forced that for that the inability to build wealth through that most Americans of means forced black people into sharecropping roles where they somehow always tended to find themselves in debt to the landowner when the growing season closed, with no hope of recourse against the ever present cooking of the books. Sharecropping is but one example of race linked obstacles that the law and private parties laid down to hinder the progress and prosperity of black people. Vagrancy laws criminalized free black men who failed to work for white landlords. Many states barred freedmen from hunting or fishing to ensure that they could not live without entering de facto re-enslavement as sharecroppers. A cornucopia of laws, for example, banning hitchhiking, prohibiting encouraging a laborer to leave his employer, and penalizing those who prompted black Southerners to migrate northward, ensured that black people could not freely seek better lives elsewhere, and when statutes did not ensure compliance, state sanctioned and private violence did. Thus emerged Jim Crow, a system that was, as much as anything else, a comprehensive scheme of economic exploitation to replace the Black Codes, which themselves had replaced slavery's form of comprehensive economic exploitation. Meanwhile, as Jim Crow ossified, the federal government was giving away land on the western frontier, and with it the opportunity for upward mobility and a more secure future, over the 1862 Homestead Act's three-quarter century tenure. Black people were exceedingly unlikely to be allowed to share in those benefits, which by one calculation may have advantaged approximately 46 million Americans living today. Despite these barriers, black people persisted. Their so-called Great Migration northward accelerated during and after the First World War. Like clockwork, American cities responded with racially exclusionary zoning and similar policies. As a result, black migrants had to pay disproportionately high prices for disproportionately subpar housing. Nor did migration make it more likely for black people to access home ownership. As banks would not lend to black people, and in the rare cases banks would fund home loans, exorbitant interest rates were charged. With black people still locked out of the Homestead Act giveaway, it is no surprise that, when the Great Depression arrived, race based wealth, health, and opportunity gaps were the norm. Federal and state governments' selective intervention further exacerbated the disparities. Consider, for example, a federal homeowners loan corporation, HOLC, created in 1933. HOLC purchased mortgages, threatened with foreclosure, and issued new amortized mortgages in their place. Not only did this mean that recipients of these mortgages could gain equity while paying off the loan, successful full payment would make the recipient a homeowner. Ostensibly to identify and avoid the riskiest recipients, the HOLC created color-coded maps of every metropolitan area in the nation. Green meant safe, red meant risky. And regardless of class, every neighborhood with black people earned the red designation. Similarly, consider the Federal Housing Administration, FHA, created in 1934, which insured highly desirable bank mortgages. Eligibility for this insurance required an FHA appraisal of the property to ensure a low default risk. But nationwide, it was FHA's established policy to provide no guarantees for mortgages to African Americans or to whites who might lease to African Americans, irrespective of creditworthiness. No surprise then that between 1934 and 1968, 98% of FHA loans went to white Americans, with whole cities, ones that had a disproportionately large number of black people due to housing segregation, sometimes being deemed ineligible for FHA intervention on racial grounds. The Veterans Administration operated similarly. One more example. The Federal Home Loan Bank Board chartered, insured, and regulated savings and loan associations from the early years of the New Deal, but it did not oppose the denial of mortgages to African Americans until 1961, and even then opposed discrimination ineffectively. The upshot of all this is that due to government policy choices in the suburban shaping years between 1930 and 1960, fewer than 1% of all mortgages in the nation were issued to African Americans. Thus, based on their race, black people were locked out of the greatest mass-based opportunity for wealth accumulation in American history. For present purposes, it is significant that, in so excluding black people, government policies affirmatively acted to dole out preferences to those who, if nothing else, were not black. Those past preferences carried forward and are reinforced today by, among other things, the benefits that flow to homeowners and to the holders of other forms of capital that are hard to obtain unless one already has assets. This discussion of how the existing gaps were formed is merely illustrative, not exhaustive. I will pass over Congress's repeated crafting of family, worker, and retiree protective legislation to channel benefits to white people, thereby excluding black Americans from what was otherwise a revolution in the status of most working Americans. I will also skip how the GI Bill's creation of middle class America by giving $95 billion to veterans and their families between 1944 and 1971 was deliberately designed to accommodate Jim Crow. So too will I bypass how black people were prevented from partaking in the consumer credit market, a market that helped white people who could access it build and protect wealth. Nor will time and space permit my elaborating how local officials' racial hostility meant that even those benefits that black people could formally obtain were unequally distributed along racial lines. And I could not possibly discuss every way in which, in light of this history, facially race blind policies still work race based harms today. For example, racially disparate tax system treatment, the disproportionate location of toxic waste facilities in black communities, or the deliberate action of governments at all levels in designing interstate highways to bisect and segregate black urban communities. The point is this: given our history, the origin of persistent race linked gaps should be no mystery. It has never been a deficiency of black Americans' desire or ability to, in Frederick Douglass's words, stand on their own legs. Rather, it was always simply what Justice Harlan recognized 140 years ago: the persistent and pernicious denial of what had already been done in every state of the Union for the white race. History speaks in some form. In some form, it can be heard forever. The race based gaps that first developed centuries ago are echoes from the past and still exist today. By all accounts, they are still stark. Start with wealth and income. Just 4 years ago, in 2019, black families' median wealth was approximately $24,000. For white families, that number was approximately 8 times as much, about $188,000. These wealth disparities exist at every income and education level, so on average, white families with college degrees have over $300,000 more wealth than black families with college degrees. This disparity has also accelerated over time, from a roughly $40,000 gap between white and black household median net worth in 1993 to a roughly $135,000 gap in 2019. Median income numbers from 2019 tell the same story: $76,057 for white households, $98,174 for Asian households, $56,113 for Latino households, and $45,438 for black households. These financial gaps are unsurprising in light of the link between homeownership and wealth. Today, as was true 50 years ago, black homeownership trails white homeownership by approximately 25 percentage points. Moreover, black Americans' homes relative to white Americans constitute a greater percentage of household wealth, yet tend to be worth less, are subject to higher effective property taxes, and generally lost more value in the Great Recession. From those markers of social and financial unwellness flow others. In most state flagship higher educational institutions, the percentage of black undergraduates is lower than the percentage of black high school graduates in that state. Black Americans in their late 20s are about half as likely as their white counterparts to have college degrees, and because lower family income and wealth force students to borrow more, those black students who do graduate college find themselves 4 years out with about $50,000 in student debt, nearly twice as much as their white compatriots. As for post secondary professional arenas, despite being about 13% of the population, black people make up only about 5% of lawyers. Such disparity also appears in the business realm. Of the roughly 1,800 chief executive officers to have appeared on the well known Fortune 500 list, fewer than 25 have been black. As of 2022, only 6 are black. Furthermore, as the COVID-19 pandemic raged, black-owned small businesses failed at dramatically higher rates than white-owned small businesses, partly due to the disproportionate denial of the forgivable loans needed to survive the economic downturn. Health gaps track financial ones. When tested, black children have blood lead levels that are twice the rate of white children, irreversible contamination working irredeemable harm on developing brains. Black and Latino children with heart conditions are more likely to die than their white counterparts. Race linked mortality rates disparity has also persisted in it and is highest among infants. So, too, for adults, black men are twice as likely to die from prostate cancer as white men and have lower 5-year cancer survival rates. Uterine cancer has spiked in recent years among all women, but has spiked highest for black women, who die of uterine cancer at nearly twice the rate of any other racial or ethnic group. Black mothers are up to 4 times more likely than white mothers to die as a result of childbirth, and COVID killed black Americans at higher rates than white Americans. Across the board, Black Americans experience the highest rates of obesity, hypertension, maternal mortality, infant mortality, stroke, and asthma. These and other disparities, the predictable result of opportunity disparities, lead to at least 50,000 excess deaths a year for Black Americans vis-a-vis white Americans. That is 80 million excess years of lost life from just 1999 through 2020. Amici tell us that race-linked health inequities pervade nearly every index of human health, resulting in an overall reduced life expectancy for racial and ethnic minorities that cannot be explained by genetics. Meanwhile, tying health and wealth together, while she lays dying, the typical Black American pays more for medical care and incurs more medical debt. We return to John and James now, with history in hand. It is hardly John's fault that he is the seventh generation to graduate from UNC. UNC should permit him to honor that legacy. Neither, however, was it James or his family's fault that he would be the first, and UNC ought to be able to consider why. Most likely, 7 generations ago, when John's family was building its knowledge base and wealth potential on the university's campus, James's family was enslaved and laboring in North Carolina's fields. 6 generations ago, the North Carolina Redeemers aimed to nullify the results of the Civil War through terror and violence, marauding in hopes of excluding all who looked like James from equal citizenship. 5 generations ago, the North Carolina Red Shirts finished the job. 4 and 3 generations ago, Jim Crow was so entrenched in the state of North Carolina that UNC enforced its own Jim Crow regulations. 2 generations ago, North Carolina's governor still railed against integration for integration's sake, and UNC black enrollment was minuscule. So, at bare minimum, 1 generation ago, James's family was 6 generations behind because of their race, making John's 6 generations ahead. These stories are not every student's story. But they are many students' stories. To demand that colleges ignore race in today's admissions practices and thus disregard the fact that racial disparities may have mattered for where some applicants find themselves today, it is not only an affront to the dignity of those students for whom race matters, it also condemns our society to never escape the past that explains how and why race matters to the very concept of who merits admission. Permitting, not requiring, colleges like UNC to assess merit fully without blinders on plainly advances, not thwarts, the 14th Amendment's core promise. The 14th Amendment's core promise. UNC considers race as one of many factors in order to best assess the entire unique import of John's and James' individual lives and inheritance on an equal basis. Doing so involves acknowledging, not ignoring, the 7 generations worth of historical privileges and disadvantages that each of these applicants was born with when his own life's journey started a mere 18 years ago. Recognizing all this, UNC has developed a holistic review process to evaluate applicants for admission. Students must submit standardized test scores and other conventional information. But applicants are not required to submit demographic information like gender and race. UNC considers whatever information each applicant submits using a non-exhaustive list of 40 criteria grouped into 8 categories: academic performance, academic program, standardized testing, extracurricular activity, special talent, essay criteria, background, and personal criteria. Drawing on these 40 criteria, a UNC staff member evaluating John and James would consider, with respect to each, his engagement outside the classroom, persistence of commitment, demonstrated capacity for leadership, contributions to family, school, and community, work history, and his unique or unusual interests. Relevant too would be his relative advantage or disadvantage as indicated by family income level, education history of family members, impact of parents/guardians in the home, and formal education environment, experience of growing up in rural or or center city locations, and his status as child or stepchild of Carolina alumni. The list goes on. The process is holistic through and through. So, where does race come in? According to UNC's admissions policy document, reviewers may also consider the race or ethnicity of any student, if that information is provided, in light of UNC's interest in diversity. And yes, the race or ethnicity of any student may or may not receive a plus in the evaluation process depending on the individual circumstances revealed in the student's application. Stephen Farmer, the head of UNC's Office of Undergraduate Admissions, confirmed at trial under oath that UNC's admissions process operates in this fashion. Thus, to be crystal clear, every student who chooses to disclose his or her race is eligible for such a race-linked plus, just as any student who chooses to disclose his or her unusual interests can be credited for what those interests might add to UNC. The record supports no intimation to the contrary. Eligibility is just that. A plus is never automatically awarded, never considered in numerical terms, and never automatically results in an offer of admission. There are no race-based quotas in UNC's holistic review process. In fact, during the admissions cycle, the school prevents anyone who knows the overall racial makeup of the admitted student pool from reading any applications. More than that, every applicant is also eligible for a diversity linked plus beyond race more generally. And notably, UNC understands diversity broadly, including socioeconomic status, first generation college status, political beliefs, religious beliefs, diversity of thought, experiences, ideas, and talents. A plus by its nature can certainly matter to an admissions case, but make no mistake, when an applicant chooses to disclose his or her race, UNC treats that aspect of identity on par with other aspects of applicants' identity that affect who they are, just like, say, where one grew up or medical challenges one has faced. And race is considered alongside any other factor that sheds light on what attributes applicants will bring to the campus and whether they are likely to excel once there. A reader of today's majority opinion could be forgiven for misunderstanding how UNC's program really works, or for missing that under UNC's holistic review process, a white student could receive a diversity plus while a black student might not. UNC does not do all this to provide handouts to either John or James. It does this to ascertain who among its tens of thousands of applicants has the capacity to take full advantage of the opportunity to attend and contribute to this prestigious institution and thus merits admission. And UNC has concluded that ferreting this out requires understanding the full person, which means taking seriously not just SAT scores or whether the applicant plays the trumpet, but also any way in which the applicant's race-linked experience bears on his capacity and merit. In this way, UNC is able to value what it means for James, whose ancestors received no race-based advantages, to make himself competitive for admission to a flagship school nevertheless. Moreover, recognizing this aspect of James's story does not preclude UNC from valuing John's legacy or any obstacles that his story reflects. So, to repeat, UNC's program permits but does not require admissions officers to value both John's and James' love for their state, their high school's rigor, and whether either has overcome obstacles that are indicative of their persistence of commitment. It permits, but does not require them to value John's identity as a child of UNC alumni, or perhaps, if things had turned out differently, as a first-generation white student from Appalachia whose family struggled to make ends meet during the Great Recession. And it permits, but does not require them to value James's race, not in the abstract, but as an element of who he is, no less than his love for his state, his high school courses, and the obstacles he has overcome. Understood properly, then, what SFFA caricatures as an unfair race-based preference cashes out in a holistic system to a personalized assessment of the advantages and disadvantages that every applicant might have received by accident of birth, plus all that has happened to them since. It ensures a full accounting of everything that bears on the individual's resilience and likelihood of enhancing the UNC campus. It also forecasts his potential for entering the wider world upon graduation and making a meaningful contribution to the larger collective societal goal that the Equal Protection Clause embodies. Its guarantee that the United States of America offers genuinely equal treatment to every person regardless of race. Furthermore, and importantly, the fact that UNC's holistic process ensures a full accounting makes it far more clear that any particular applicant of color will finish ahead of any particular non minority applicant. For example, as the district court found, a higher percentage of the most academically excellent in state black candidates, as FFFA's expert defined academic excellence, were denied admission than similarly qualified white and Asian American applicants. That, if nothing else, is indicative of a genuinely holistic process. It is evidence that, both in theory and in practice, UNC recognizes that race, like any other aspect of a person, may bear on where both John and James start the admissions relay, but will not fully determine whether either eventually crosses the finish line. The majority seems to think that race blindness solves the problem of race-based disadvantage, but the irony is that requiring colleges to ignore the initial race-linked opportunity gap between applicants like John and James will inevitably widen that gap, not narrow it. It will delay the day that every American has an equal opportunity to thrive regardless of race. SFFA similarly asks us to consider how much longer UNC will be able to justify considering race in its admissions process. Whatever the answer to that question was yesterday, today's decision will undoubtedly extend the duration of our country's need for such race consciousness. Because the justification for admissions programs that account for race is inseparable from the race-linked gaps in health, wealth, and well-being that still exist in our society, the closure of which today's decision will forestall. To be sure, while the gaps are stubborn and pernicious, black people and other minorities have generally been doing better. But those improvements have only been made possible because institutions like UNC have been willing to grapple forthrightly with the burdens of history. SFFA's complaint about the indefinite use of race-conscious admissions programs, then, is a non sequitur. These programs respond to deep-rooted, objectively measurable problems. Their definite end will be when we succeed together in solving those problems. Accordingly, while there are many perversities of today's judgment, the majority's failure to recognize that programs like UNC's carry with them the seeds of their own destruction is surely one of them. The ultimate goal of recognizing James' full story and potentially admitting him to UNC is to give him the necessary tools to contribute to closing the equity gaps discussed in Part 1, so that he, his progeny, and therefore all Americans can compete without race mattering in the future. That intergenerational project is undeniably a worthy one. In addition, and notably, that end is not fully achieved just because James is admitted. Schools properly care about preventing racial isolation on campus because research shows that it matters for students' ability to learn and succeed while in college if they live and work while at least some other people who look like them and are likely to have similar experiences related to that shared characteristic. Equally critical, UNC's program ensures that students who don't share the same stories, like John and James, will interact in classes and on campuses, and will thereby come to understand each other's stories, which amici tell us improves cognitive abilities and critical thinking skills, reduces prejudice, and better prepares students for postgraduate life. Beyond campus, the diversity that UNC pursues for the betterment of its students and society is not a trendy slogan. It saves lives. For marginalized communities in North Carolina, it is critically important that UNC and other area institutions produce highly educated professionals of color. Research shows that black physicians are more likely to accurately assess black patients' pain tolerance and treat them accordingly, including, for example, prescribing them appropriate amounts of pain medication. For high-risk black newborns, having a black physician more than doubles the likelihood that the baby will live and not die. Studies also confirm what common sense counsels: closing wealth disparities through programs like UNC's, which, beyond diversifying the medical profession, open doors to every sort of opportunity, helps address the aforementioned health disparities in the long run as well. Do not miss the point that ensuring a diverse student body in higher education helps everyone, not just those who, due to their race, have directly inherited distinct disadvantages with respect to their health, wealth, and well-being. Amici explained that students of every race will come to have a greater appreciation and understanding of civic virtue, democratic values, and our country's commitment to equality. The larger economy benefits too. When it comes down to the brass tacks of dollars and cents, ensuring diversity will, if permitted to work, help save hundreds of billions of dollars annually, by conservative estimates. Thus, we should be celebrating the fact that UNC, once a stronghold of Jim Crow, has now come to understand this. The flagship educational institution of the former Confederate state has embraced its constitutional obligation to afford genuine equal protection to applicants, and by extension to the broader polity that its students will serve after graduation. Surely that is progress for a university that once engaged in the kind of patently offensive race dominated admissions process that the majority decries. With its holistic review process, UNC now treats race as merely one aspect of an applicant's life, when race played a totalizing, all encompassing, and singularly determinative role for applicants like James for most of this country's history. No matter what else was true about him, being black meant he had no shot at getting in the ultimate race linked uneven. At getting in, the ultimate race linked uneven playing field. Holistic programs like UNC's reflect the reality that black students have only relatively recently been permitted to get into the admissions game at all. Such programs also reflect universities' clear eyed optimism that one day race will no longer matter. So much upside. Universal benefits ensue from holistic admissions programs that allow consideration of all factors material to merit, including race, and that thereby facilitate diverse student populations. Once trained, those UNC students who have thrived in the university's diverse learning environment are well equipped to make lasting contributions in a variety of realms and with a variety of colleagues, which in turn will steadily decrease the salience of race for future generations. Fortunately, UNC and other institutions of higher learning are already on this beneficial path. In fact, all that they have needed to continue moving this country forward toward full achievement of our nation's founding promises is for this court to get out of the way and let them do their jobs. To our great detriment, the majority cannot bring itself to do so. The overarching reason the majority gives for becoming an impediment the overarching reason the majority gives for becoming an impediment to racial progress is that its own conception of the 14th Amendment's Equal Protection Clause leaves it no other option, has a wholly self referential two dimensional flatness. The majority and concurring opinions rehearse this court's idealistic vision of racial equality, from Brown forward, with appropriate lament for past indiscretions. But the race linked gaps that the law, aided by this court, previously founded and fostered, which indisputably define our present reality, are strangely absent and do not seem to matter. With let them eat cake obliviousness, today the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. And having so detached itself from this country's actual past and present experiences, the court has now been lured into interfering with the crucial work that UNC and other institutions of higher learning are doing to solve America's real world problems. No one benefits from ignorance. Although formal race linked legal barriers are gone, race still matters to the lived experiences of all Americans in innumerable ways, and today's ruling makes things worse, not better. The best that can be said of the majority's perspective is that it proceeds, ostrich like, from the hope that preventing consideration of race will end racism. But if that is its motivation, the majority proceeds in vain. If the colleges of this country are required to ignore a thing that matters, it will not just go away. It will take longer for racism to leave us, and ultimately, ignoring race just makes it matter more. The only way out of this morass for all of us is to stare at racial disparity unblinkingly, and then do what evidence and experts tell us is required to level the playing field and march forward together, collectively striving to achieve true equality for all Americans. It is no small irony that the judgment the majority hands down today will forestall the end of race based disparities in this country, making the colorblind world the majority wistfully touts much more difficult to accomplish. As the Civil War neared its conclusion, General William T. Sherman and Secretary of War Edwin Stanton convened a meeting of black leaders in Savannah, Georgia. During the meeting, someone asked Garrison Frazier, the group's spokesperson, what freedom meant to him. He answered, placing us where we could reap the fruit of our own labor and take care of ourselves, to have land and turn it and till it by our own labor. Today's gaps exist because that freedom was denied far longer than it was ever afforded. Therefore, as Justice Sotomayor correctly and amply explains, UNC's holistic review program pursues a righteous end, legitimate because it is defined by the Constitution itself. The end is the maintenance of freedom. Viewed from this perspective, beleaguered admissions programs such as UNC's are not pursuing a patently unfair, ends justified ideal of a multiracial democracy at all. Instead, they are engaged in an earnest effort to secure a more functional one. The admissions rubrics they have constructed now recognize that an individual's merit, his ability to succeed in an institute of higher learning and ultimately contribute something to our society cannot be fully determined without understanding that individual in full. There are no special favorites here. UNC has thus built a review process that more accurately assesses merit than most of the admissions programs that have existed since this country's founding. Moreover, in so doing, universities like UNC create pathways to upward mobility for long excluded and historically disempowered racial groups. Our nation's history more than justifies this course of action, and our present reality indisputably establishes that such programs are still needed for the general public good, because after centuries of state sanctioned and enacted race discrimination, the aforementioned intergenerational race based gaps in health, wealth, and well being stubbornly persist. Rather than leaving well enough alone, today the majority is having none of it, turning back the clock to a time before the legal arguments and evidence establishing the soundness of UNC's holistic admissions approach existed. The court indulges those who either do not know our nation's history or long to repeat it. Simply put, the race blind admissions stance the court mandates from this day forward is unmoored from critical real life circumstances. Thus, the court's meddling not only arrests the noble generational project that America's universities are attempting, it also launches, in effect, a dismally misinformed sociological experiment. Time will reveal the results. Yet the court's own missteps are now both eternally memorialized and excruciatingly plain. For one thing, based apparently on nothing more than Justice Powell's initial say so, it drastically discounts the primary reason that the racial diversity objectives it excoriates are needed, consigning race related historical happenings to the court's own analytical dustbin. Also, by latching onto arbitrary timelines and professing insecurity about missing metrics, the court sidesteps unrefuted proof of the compelling benefits of holistic admissions programs that factor in race. Hard to do, for there is plenty. Simply proceeding as if no such evidence exists. Then, ultimately, the court surges to vindicate equality, but Don Quixote style, pitifully perceiving itself as the sole vanguard of legal high ground when, in reality, its perspective is not constitutionally compelled and will hamper the best judgments of our world class educational institutions about who they need to bring onto their campuses right now to benefit every American, no matter their race. The court has come to rest on the bottom line conclusion that racial diversity in higher education is only worth potentially preserving insofar as it might be needed to prepare Black Americans and other underrepresented minorities for success in the bunker, not the boardroom, a particularly awkward place to land in light of the history the majority opts to ignore. It would be deeply unfortunate if the Equal Protection Clause actually demanded this perverse, ahistorical, and counterproductive outcome, to impose this result in that clause's name when it requires no such thing, and to thereby obstruct our collective progress toward the full realization of the clause's promise is truly a tragedy for us all. Well, that was a good read, and as always, if there's any case you'd like me to read, just drop in the comments and we'll be happy to take a look. Thank you.